does the fact that you are married take away your right as a person to acquire your own property during the subsistence of the marriage? The answer is no. Article 22 of the 1992 Constitution states that a spouse shall not be denied a reasonable provision out of the estate of a spouse, whether or not that spouse died leaving behind a will. However, Article 18 of the 1992 Constitution also states that a person has the right to acquire properties either by himself or in association with others. How do we juxtapose these two constitutional provisions? Well, in marriage, when a marriage is being dissolved, there is a presumption that property that are acquired during that marriage are jointly acquired by the parties. However, in law, a presumption is an assumption. That means that unless contrary evidence is led to displace that presumption, the court will hold that as a status quo. Now, when a court is confronted with a matter, the court looks at the circumstances of the case, the relationship between the parties, and the evidence before it, and its duty as a court to do justice. So if the court is satisfied on evidence that although a particular property was acquired during the marriage, it was single-handedly acquired by one person without the direct or indirect contribution of the other, the court will give that property to that particular spouse. Our courts are replete with cases of this nature. Notable among them are Benchienchil versus Benchienchil, the case of Finn versus Finn, among others. So please, the fact of marriage does not take away your constitutional right to acquire properties on your own, even within the subsistence of the marriage. This is the episode of Learning the Law with Ajimai. Have a lovely day.